The onus of proof sits with the inspectorate to demonstrate why they believe there has not been fundamental compliance with any particular regulation.
Where an employee may feel that their employer is non-compliant,
Yeah.
and the same burden of proof then lies with the employee.
Where there is a genuine complaint made by an employee, either by an employee themselves or through the health and safety committees, the employer would have to investigate that complaint as a reasonable employer. New codes of practice, interestingly, ones relating to mental health in the workplace.
Welcome back to My Safety Hub. We are at the Saiosh Conference for 2025, and we're once again joined by Kate Collier from Weber Wentzel. It's good to see you again.
Thank you very much. Great to be here.
I really enjoyed your talk this morning. Couple of controversial points. Maybe I should leave the easy questions for last. Maybe we need to jump into the controversial one first. And we were discussing it offline before we started rolling now, and it's the question about reasonable practice. You mentioned now that there's a bit of a flip side with regards to the application of reasonable practice, and it moves much more into the burden of proof. And that should someone allege that a party, be it an employer or an employee, is non-compliant or not doing what they're supposed to do in terms of the law, the requirements of legislation, it's on the person alleging to prove the non-compliance.
Yes.
Can you talk us through this, please?
Yeah, sure. So I think it's probably two different aspects that come out of the judgment, but which ultimately need to be seen together to inform how an employer complies with the Act. So the first is as you said, the Truworth judgment confirms that it's not for an employer to have to prove that they have complied with the Act. If there is an allegation by the inspector that there is non-compliance with the Act, that non-compliance must be demonstrated by the inspectorate if they want to take punitive action against the employee. Okay. It can't, the inspector has to satisfy himself, gather evidence, and be able to demonstrate that non-compliance. It can't just simply be a bald statement and then the employer is left having to prove why they did comply.
Okay, sorry to interrupt, but I just want to maybe segment, because there's a lot of information here. So first of all, if you're looking at the employer's responsibility not to prove their compliance, that first part of your feedback that you gave us now, does that only apply in cases where someone may be presuming and assuming and maybe attacking the employer or any other party to say, well, you're non-compliant?
Yes, I mean, there's always an obligation on every employer to discharge their obligations under the Act and to make sure that they are taking reasonably practical measures to protect the health and safety of their employees. Okay. What this is relevant for is in the context of an allegation of non-compliance by a regulator. So if you're facing a contravention notice or a prohibition notice, or even a prosecution, it's no longer acceptable. Well, I don't think it ever was, but the courts have confirmed that it's not acceptable. Okay. For there simply to be a statement by an inspector that there has been non-compliance with the regulation, and then for the employer to have to demonstrate why they did. Okay. The onus of proof sits with the inspectorate to demonstrate why they believe there has not been fundamental compliance with any particular regulation. Okay. The employer, of course, must still defend that allegation. Yes. And rise to the allegation, but the allegation must be founded in some level of fact. It can't just be the opinion of an inspector.
Okay. Is this then only in the cases like you've mentioned now where the regulators are doing the inspections, doing investigations, having formal inquiries? Or does this also apply in cases where an employee may feel that their employer is non-compliant and the same burden of proof then lies with the employee?
So it'll be different in the event that there's an employee complaint. Okay. Because where there is a genuine complaint made by an employee, either by an employee themselves or through the health and safety committees, the employer would have to investigate that complaint as a reasonable employer. Okay. And they would have to then gather the information, assess whether there is basis for the complaint, and then put in place the remedial measures, if any. Okay. If that employee, however, escalates that complaint to the regulator and the regulator comes to site to investigate it, the same process would then commence. The inspector would have to investigate, gather the information, and if they're going to make a finding that there's non-compliance, there needs to be the proof to demonstrate that.
So from a culture building perspective then, and with the Occupational Health and Safety Act being a transparent act, isn't it better then just for employers to demonstrate that compliance from the get-go?
Absolutely.
And not to sit back and wait for complaints or formal inquiries, things going wrong. Why not just demonstrate it off the bat?
Absolutely. I mean, and there should be no bar to an employee or an employer doing that. Why this is important and where the protection comes in for an employer is that where these allegations are made through formal legal processes, there are significant legal consequences that come with it. Closure of a site, recommendations for prosecutions. If the draft amendment bill comes in the way it is, there could be admin fines being imposed. And I think this just gives that level of legal balance to really just make sure that we're not going to have a situation where employers are being accused of all level of contraventions without there being the sufficient basis upon which to ground that contravention and to demonstrate that it has actually occurred.
Okay. And then take us through the link or the finding, the case that you spoke about where there's now been proven that there's a direct link between these contraventions and possible human rights violations as well.
Yeah, so the Matthys judgment, very broadly, the employee complained that they were being moved off, their office premises were being moved, and the premises that they were meant to be put into was uninhabitable, essentially. And the court held that where you have contraventions of that level, where employees would be so unsafe in that workplace, there's a link between an employee's constitutional right to dignity, life, privacy, a safe workplace, and a contravention of the OSH Act could then in turn amount to a contravention or a failure to recognize someone's rights under the Bill of Rights.
Constitutionally speaking, what's the impact then from that perspective?
It'll mean that there will be greater judicial oversight.
Okay.
And there can be further contraventions imposed. And also there would be greater ability for the inspectors to take action against it where they believe that there's a constitutional violation.
Okay. And what are the possible penalties that can be imposed in this regard?
So the penalties would still be the penalties under the Occupational Health and Safety Act.
Okay.
Which, as you know, currently would be prosecution. But if the Act comes in the way we expect it will soon, there will also be significant admin fines.
Okay. All right. Really interesting. I'm a little bit lost for words when I'm just thinking about the impact, as it relates to possible human rights violations. The constitutional part I understand. I'm a little bit unclear as to, if the penalties are still being imposed under the Occupational Health and Safety Act and its regulations.
Well, those are the penalties that the inspectorate can recommend. It would be for someone to bring other claims or cases, and they would then base it on those constitutional rights.
Okay.
But from an OSH Act perspective,
yes,
the penalty still sits from an inspector enforcing through their powers under the Act.
Okay, I see. Okay, and then what are some of the significant changes in legislation or regulations that have come about in the last year since we last spoke?
Sure, there have been a couple. We've had new regulations published. So there's the new physical agents regs, consolidating things like, thermal stress, vibration. What else is in there? Ergonomics, a bit of ergonomics, bit of noise. So it really just updates a lot of those regulations. We've had new noise regs from the mine health and safety side of things. We've got new machinery regulations dealing with winders, new codes of practice, interestingly, ones relating to mental health in the workplace. Lots of legislative changes.
A code of practice for mental health. How?
Well, the steps that employers have to take to identify that as potentially impacted by and the protections of it in the workplace, and the measures that employers need to take to help employees, I suppose, protect their mental health in the workplace.
Is this only in the Mines Safety Act?
So that is a code of practice under mining legislation.
Right.
But there are similar obligations for mental health protection in an OSH Act environment.
So from an OHS perspective, if you think about the mental health possible considerations that there could be, and there's lots, this should be managed from the risk assessment perspective as well.
Absolutely. And I think there's actually another speaker today later speaking about mental health in the workplace. It's a significantly growing occupational health issue. Understanding the role that workplaces play in employee mental health but also the role that employers might have in safeguarding employee mental health, even where those issues are extraneous to the workplace. So employees who, for example, suffer with severe depression, what is the role of employers in dealing with that?
And I was going to ask that question now, because you went to depression, but I mean, you've got a whole long list of other things that could mentally be, an issue for people. And how specific do we get? If now we're back with reasonable practice, I've got to do my risk assessment. Do I list ADHD? Do I list depression? Do I list whatever the issue may be, and how I'm going to mitigate and control and try and eliminate those issues?
Yeah, I mean, you may need to, depending on your workplace and the things that you're identifying during your risk assessment. I don't think it's for the employer to eliminate them. A lot of these things are outside of the employer's sphere of control, but the employer would certainly have to know how to cater for them in the workplace.
And how long is that piece of string then?
Exactly.
You understand where I'm going?
Absolutely.
Because this can be abused as well. Fake it till you make it kind of scenario, where a person may say, well, I've got ADHD, so I can't do this type of work, or I'm depressed, I don't feel like working today.
Yeah, so there are numerous, particularly from a labor law side of things, mechanisms that can be used in, to identify whether or not an employee is able to be accommodated in the workplace, and the way employees can be assisted and protected. But there's also the balancing necessity to ensure that what the employer needs to achieve, i.e. a productive workforce, can also be protected. So there are checks and balances in the legislation.
Okay. Well, I'm thinking every employer listening is hoping for those protections as well. My last question is purely an opinionated question. In your opinion, when do you think will we see the new Act be promulgated?
I have no idea. The last draft we saw, I thought was pretty ready for publication. I'm not sure what the holdup is. There's also draft amendments to the Mine Health and Safety Act. I'm not sure whether they're looking to bring them out at the same time. I've got zero touchstone on that.
Okay.
I've been watching it through the Parliamentary Process Committee. I haven't seen any updates from there. Your guess is as good as mine.
So we'll wait and see.
We'll wait and see.
Thank you. And thank you for your time once again.
Such a pleasure.
It's great to have you.
Thanks.
Thank you.